Good morning. Good morning, everyone. Hello, Chairman. Hey, Nene. Hey, Tall Glass. How are y'all? It's me, Lauren Cadillac, aka OG Cadillac, aka Mother of the Decade, aka your favorite internet lawyer. I hope everyone is doing really well today. I know I sure am. I'm very happy because it is nice and cold outside. I got a house with a pool, so I'm really excited to have a pool this summer, but I am not excited for the heat. All right, y'all. I was so excited. I turned on YouTube and found this Tay-K murder trial. Okay. And I started watching it, and we're going to watch it together, and I'm going to reenact my surprise and excitement, okay? I'm going to reenact it for you. You guys are so lucky. Okay, here we go. I think I'm watching this. Oh, no. I was. One thing I got to say is Texas lawyers be talking slow. Okay. So let's see. I don't hear anything. My desktop audio is not working. No. Belen, if you're listening, I don't know which speaker to use for my desktop audio. Belen, if you're out there, I need your help. Okay, well, we're not going to reenact my surprise yet. I got to figure. Oh my God, you guys. Okay, so I don't know if you know this about me yet, but I am a big astrology person, okay? And I love astrology. So Mercury is currently in retrograde, and that happens until April 3rd. Sorry, I'm texting Balloon because I don't think she's watching right now. Oh no, here she comes. Okay, so Mercury is in retrograde right now, and how that manifests in my life is that all technology just goes. Nothing works. No. Okay, so this is Mercury retrograde, you guys. This is what it does to me every time. I'm so sorry. So sorry for our brief technical delay. Let's see. Nope. 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 Oh my God, you guys. All right, well, I'll just talk until Belen sends me instructions on how to fix this, because none of the choices I have here in speakers is working. Of course. Of course. Okay, well, while we work on figuring out how to get these damn speakers to work, I wanted to tell you about May, and May 6th specifically. So I am coming to New York City in May to view the Diddy trial. I'm going to watch the first 2 days, hopefully in person, maybe in an overflow room, we'll see, in New York City live. Now, those are going to be jury selection days, okay? But that'll be cool because I could see what a federal jury pool looks like. I don't even know. I've never had a federal jury. So I'm very interested in seeing what a federal jury pool looks like. And also be interesting to listen to the voir dire questions because, or they probably call it voir dire, but it'll be interesting to see how many people have not heard of the case or the trial or Diddy himself, and how many people have, so that to me is quite interesting. So I'll get to see that. Thank you, Chairman, for the for the compliment, and thank you everyone for your patience and bearing with me. Boleyn, I sent her a photo of the speaker issue, and she is looking it up. Okay, this has to be on default. Okay, now what? Thank you for bearing with me, y'all. Let's see, hold on. No. It's called desktop audio. Alright, so our software had an update yesterday, and so these kinks were supposed to be worked out before I got here today, but apparently they did not get that way, so it's okay. Thank you for bearing with me. Alright, so I'm going to be looking at I'm going to be watching the jury selection at the Diddy trial, at least day 1 and day 2. And on day 2, which is the 6th, I will be hosting a meet and greet. So if you would like to attend the meet and greet, I will share details on my community page. I'll give you the name of I think it's a tavern or a pub. It seems really cool. They got bras hanging from the ceiling. So I'm going to wear an old bra. See if I can donate it to the ceiling. Get a good old Texas bra out there, okay? Okay, hold on. I got to do an experiment. Okay.
Understood. I'm ready.
What? Whoa, that's weird. I said okay. Alright, so May 6th, we're going to do the meet and greet. It'll be at 6 p.m. in New York City. I think it's in Manhattan. I don't know. I don't know anything about New York. And I'm really looking forward to it. And anyone that is going to be out there or is near the area or whatever, anyone that's interested, I hope to see you at the meet and greet. I think that will be really fun. I had a great time at the Atlanta meet and greet, and I'm hoping to have an equally good amount of time at this one. I will again take my camera so I can live stream the meet and greet like I did last time. Boom. Okay, there is a button in the middle of the monitor. If you guys had any idea how bad I am at technology and then having to do this through text, there's nothing in the middle of the monitor. I have no idea. There's no button in the middle of the monitor, guys, so. So sorry. If you're on rewatch, please just fast forward through this crap. This is crazy. I'm so sorry, guys. Under the monitor. Don't know what this means. Oh, here? Okay, I don't know, guys. I don't know what's... She's trying to describe this to me. I have no idea what she means. What am I supposed to do? Push this? Okay, I pushed it, Balloon. Oh my god, you guys. I'm so sorry. I am so sorry. Someday we'll figure this out. I wish I had a screen that just said brief hold. Pause while I try to figure it out. Hello. Hi, Hameen. Oh, good morning. How are you? I'm so excited to see Hameen. She's a friend of mine who lives in South Korea. She's a wonderful, brilliant, talented young woman. So hi, Hameen. Unfortunately, we are having technical difficulties, so give me a minute. Hameen, you met Bolin, I think. I'm working with Bolin through text, so forgive me. Oh my god, you guys, I'm so sorry. Let's see. Oh, hold on. Oh, fudge. Ah, guys, I am so sorry. Hameen, I'm so sorry. I'm supposed to be playing videos. I'm supposed to be showing you my surprise. I'm going to reenact something here in a minute. But we are having the worst technical difficulties ever. Alright, I'm going to be so good at this in a minute. Alright, let's see if this works now. Nope, no worky. Okay, now the screens are melting. Oh, see if it worked. Ah! Nope. Oh my god, guys. Ugh! Can y'all hear the video? Can anyone hear the video? Hey, Jiggy. I'm sorry we're having super technical difficulties today. I don't understand what has happened. For some reason, my desktop audio is not working. We did an update yesterday, and I asked that this all be squared away. That obviously, it probably worked yesterday. But knowing me, coming in here, it's like, nah, we're not gonna work. Nah, screw Lauren. She's only live. Yeah. Medea, Real Tech. See if that works. Nope. Let's try the next one. Well, that sucks. I'm so sorry, guys. Like, this is some real BS. This really pisses me off a lot. Okay, so
And the Academy Award
with
for worst actor.
hold on. Did y'all hear that? All of a sudden I can hear. All right, so hold on. Fucking shit. All right. Well, I can hear. So here's what I'm going to reenact. I'm going to react to my response. This is the Tay-K murder trial. This is going on in Bexar County. It's going on right now. This was a few days ago. This is the defense table. This is the prosecution table. Okay? Bexar County does their stuff really weird. Everyone just kind of like piles in and then they send you off to other courts. So, okay, good. I think the sound is repaired. I do not know what happened. I swear to you. I think when I admitted out loud how upset I was, then it was like, oh, okay, maybe I'll work. All right. Here we go. Nope, this one doesn't work. Okay, maybe it's just this one. All right, so the judge is talking, and these guys stand up, and this guy here announces himself and says, I am John Hunter for the defense. And I go, I know John Hunter. Oh my God, I know John Hunter, the defense attorney. Shut the That is an exact reenactment of how I reacted. You guys, I was so excited. I immediately got on Facebook, went to my little friend John Hunter. Now, he was a year behind me, right? So I graduated in 11. That means he graduated in 12. So he and I didn't have like core classes together. We didn't really get to know each other super closely. But from what I understood of him, he was very smart. I'm talking very smart. You could tell he had the potential to be a phenomenal attorney. And so when I was like, now I get to see him live, like I actually get to watch him at work. I wish this one worked because there were some really good, on that first day, there were several things I was like, ooh, I'm going to point this out. Ooh, I'm going to point this out. So for instance, hold on, I'm trying to find the videos. The defense at one point made a relevance objection, and the prosecution did exactly what I expect them to do, which is then word for word explain why what they're trying to do is relevant and why it should come in. And that is not good. Like, that is not good for the defense. So when they made that objection, I didn't think that was the greatest objection. Hopefully, I'll get a working video. So I know John Hunter. I immediately messaged him on Facebook like, oh my God, I'm watching you. I'm so excited. I have a YouTube channel. Will you do an interview with me after the trial? And y'all, he said yes. He said he's going to come do an interview with me. So we'll get that actually worked out before we do it. We'll experiment 10, 15, 20 times until we figure out how to get it right. And then I will have Tay-K's defense attorney as a guest on the show. So excited. So this was the first time someone I went to law school with was like, I've watched, like, this is the first time I've seen them like on YouTube. I've seen many people I work with at court, on Zooms with court, you know, that kind of stuff. But this is the first time I've seen one on YouTube in action. So this is just thrilling to me. I don't fully understand, like, the facts of the case yet. There's something about some Hispanic kid is in the back seat. I feel like he gets out. He jumps on the hood and he stomps on the window. And when he does that, a kid in the passenger seat gets out and shoots him dead. But I think they're trying to steal the kid's car. I don't fully understand yet. All right, so here we go. This sound is working, so I'm going to blame the video. It wasn't me and Belen. We know what we're doing. It's law and crime's fault. Okay, here we go.
Raise your right hand. Do you solemnly, oh, right. That's okay. Do you solemnly swear?
Just so you know, everyone in San Antonio looks like this. Like this is such this is such a good display of like San Antonio's population. Also, the judge puts her bag here every time, and I love that. But Lynn was like, she uses her bag as like a background prop, and it's fabulous. Good on her. And she had a different bag yesterday, so she's changing her bag every day, which I also love.
Affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yeah. All right, you can lower your hand. Make sure you keep your voice up so that members of the jury can hear.
1.5, do not complain.
You'll state your name and spell your last name, please.
Ana Delgado, Delgado.
All right, state, you may proceed.
Thank you, Honor. Hi, how you doing, Mr. Delgado?
Hi, doing good.
I think we spoke previously, but one, let me just ask, do you currently live in San Antonio, Texas?
Yes, I do.
And how long have you lived in San Antonio, Texas?
Like over 23 years.
23 years? Okay.
I was.
And at roughly 5 o'clock or so in the afternoon, were you...
Okay, now they're going to kind of describe what happened, but I don't understand it. And Jiggy, you don't understand it either, which makes me feel better. It doesn't make a lot of sense to me. I don't fully understand. She's an eyewitness, like she's there. So let's listen to what she says.
Still at work, or what were you doing?
I was already off of work, so my husband was picking me up from work.
And this Papa Do's restaurant, where is it located here in San Antonio?
Off of 410.
And is there any intersections close to that?
It's McCullough and Jones Mossburger.
Okay.
Mhm.
And
It's in between.
so when your husband, you said your husband was coming to pick you up,
Mhm.
and what kind of car did you drive, or did he drive at that time?
We had a blue.
Where they're at, McCullough and 410 is very populated. I showed last week a map of San Antonio, and I showed you they have Loop 410, but then they also have Loop 1604, right? So 410 was their first loop. And they built this huge, beautiful mall called North Star Mall. And there's like a giant boot outside of it, which is relatively famous. Okay. So they are out in this super populated area near all this shopping, near these damn restaurants, obviously near a Chick-fil-A. You know, they're really out in a populated area. It's 5 p.m. It's bright and sunny outside.
And you remained on the access road at this time?
Correct.
And when you were coming up to the intersection, you mentioned McCullough. What did you do there?
We were to stop because the light was red.
And do you recall what lane you were in?
In the far right.
So far right lane?
Left, sorry. Left. Oh, wait. Yes, all right.
Far.
Towards the, what is it? Wait. Left side, sorry.
Okay.
Right? Well, yeah. It was towards the hotel that
Okay.
I too am directionally challenged. I feel like directions are like math, and that's
Okay. So that's why your mouth, it maybe little slurred words or something
Correct.
like that. Okay. And that's about a week ago.
Yes.
Okay. Okay. Thank you. I'm going to show you what's been marked State Exhibit number 3. And if you don't mind, can you point out on there where you were located when you came to the stoplight at that intersection?
Roughly on this side, right?
On this side over here. So you're pointing at that portion closest to the hotel side?
Correct.
And
Mhm.
so if we're looking at that, what side of the street would that be on?
It's gonna be on right.
The right side. Okay, so just to confirm, you're right about here,
Mhm.
and that's where you stopped, and that's on the far right side, closest to the hotel.
Closest to the hotel, correct?
All right. When you stopped at this stoplight, were there any vehicles in front of yours?
Yes, there was.
What one do you recall? How many were in front of you?
Well, the one vehicle in front of me, just the black 4-door vehicle. That was in
okay. So the black 4-door vehicle is important.
front of us. Mhm.
So that's sort of why you're here today. And
Here's Tay-K.
you discussed this case with myself and other prosecutors at times. Is that correct?
Correct.
Have you ever discussed it with defense counsels that you're aware of? Okay, or any other investigators?
No.
Okay. Now, when you stop at this light, you mentioned the black 4-door car in front of you.
Mhm.
Do you recall how far you were from this car when you came up? to
Probably
the
a few feet away from it. Mm-hmm.
So would that be sort of like a normal distance when you're
Normal distance as you're coming to a stop right behind a vehicle.
stopping? And did anything bring your attention to that vehicle in front of you?
Yes.
Can you please describe to the jury?
The vehicle.
Okay, by the way, the day before, they interviewed all the people from the vehicle in front of the black vehicle, and the people in the front, there was 2 people in the front seat. There were 3 adults in the back seat and a person who had a baby on her lap. And so the defense did a really good job of pointing out, like, you're seeing this from the rearview mirror, you know, there's all these people in the car, maybe you didn't see it that clearly. Okay, so now this lady, she's behind, so she would have a much better view of actually what happened.
People started like moving side to side as if they were playing inside the vehicle. So that's what caught my attention, because it was just swaying. There was movement in the car. That's why I was like more attentive to that. I did see the back passenger side open, the door open. Then they closed it. They opened it again, and they pushed, which is the victim, out of the vehicle. Then they closed the door, so the victim was outside of the vehicle trying to open the door. He started yelling for help. He went around to the other side of the vehicle to try to open.
Okay, so they have the victim in the back seat. They push him out. He then tries to get back in the car. He starts yelling for help. No one calls for help.
Open the door.
That's why you yell fire. You don't yell help, you yell fire. People are more willing when there's a fire to help than they are to actually help.
They were all locked. So then the light turned green. The gentleman went to the front of the vehicle and jumped on the hood. Then he held on. The light turned green. Of course, the vehicle started moving.
So the guy gets out, he jumps on the hood, the light turns green, car starts moving.
That vehicle started going, and it kind of sped up. It started maneuvering side to side to get the gentleman off. Of course, it didn't. He held on. I thought they were going to get on 410, but then they turned into Chick-fil-A.
Okay. And let me.
Okay, so the kid's holding on for dear life to the hood, and they turn in the Chick-fil-A parking lot.
Ask you this: when you saw this individual that was, I think you said pushed out, or I'm sorry, that's not pushed out or thrown out of the
Thrown out.
do you remember if that was a male or female?
It was a male.
And do you remember if his race, or was he Hispanic? Was he black?
Hispanic.
Okay. And did you, when you saw this individual jump on the hood,
Mm-hmm.
you said he held on.
Correct.
How was he holding on?
On the hood, closer to the windshield. So yeah, his face was facing the windshield.
And so what was he standing up holding on, or do you recall?
No, he was laying flat on the hood.
Fury on the overhead.
Okay, so kid gets out on the hood, they shoot him.
The photo that you just described, and you're stating that this is your vehicle on the access road?
Right.
And is this that
They're pointing at him out.
4-door black vehicle?
Correct.
Thank you. And is this there's an individual on the, is there somebody on that hood?
I'm gonna object.
Well, what is your objection?
Well, the predicate was laid that this is a photograph.
Okay. This judge is how I anticipate a judge to behave. Okay? She is exactly what I expect out of a Texas judge. She runs this courtroom. She makes rulings. She's decisive. I like her. I like Judge Boyd. If you're in Bexar County, re-elect her.
Of her vehicle, and now he's
Because
asking
this is my friend John objecting.
whether someone's climbing on the hood, implying that it's the vehicle.
Okay, so what is your legal objection, counsel?
That she either she has no personal knowledge, or it isn't what the state purported it to be when they offered the exhibit. I don't know which.
Okay, so she wants a legal objection. He gives
All
her.
right, so, state, you may lay your foundation into both parties. If you're going to use the Elmo and you want a witness to point to something, I'm going to ask, because it will be easier for the jurors, it's easier for the parties, if the person will step down. And whenever you have to step down into the well of the court, just remember to keep your voice up so that the jurors can hear as well.
Okay.
Now, with regards to your question, if you'll step down, please. They have something on the Elmo, and then ask your question, make your objection, and the court will make a ruling.
Compare and contrast that with dear old Glanville. Okay. Glanville does not ever, he did not remain calm. Like, that judge was so calm, so precise. Just give me the legal ruling, or give me the legal objection. I'm going to make my ruling. I don't know where, but one morning I heard John, the person I know who will be live on this show and we will interview about the trial, say something about, well, the court and prosecution might want this. And the judge was like, I don't want anything. I just want to hear the facts and make rulings on law. I said, okay, Judge Boyd, that is what we want. That is exactly what we want from a judge. Full stop. Like, that is exactly what we expect from a judge, and she is doing a great job. So I'm going to keep watching that case, and I'll hopefully figure out what's going on. I think they were trying to steal the kid's car. I'm thinking like the group of them got into the car and then they were trying to push the kid out and take his car, and that's why he jumped on the hood. When they pulled into the Chick-fil-A, the kid stood up and he kicked the windshield and it cracked. And that is when the passenger got up, got out, popped him, and then they sped off. And that is pretty much when people started calling 911. So the kid's on the hood, you're not calling 911. The kid's screaming help, you're not calling 911. You see him fighting in the car, you don't call 911. It's not until someone's actually laying on the ground that they call 911. I don't know, man. I don't know. Okay, so that's in Bexar County. That's San Antonio. That's down the street. I'm going to watch the rest of it, and hopefully there's a verdict by next week, and hopefully John can come next week. That would be so cool. Okay, now, on to Melly. Melly had some big wins this week. If you remember last week, I read to you the defense's motion to have the state hand everything over, and that they had already ignored the judge's order. And so they went in and they were going to have motions hearings. The state asked for more time, and the judge was like, nah. So then let's see if we can get to the nah part. All right.
That Mr. Anderson, Mr. Benjamin, Ms. Liberty, Mr. Anderson is present, and Mr. Demity likewise is present. From Mr. Picanza? Is that
No, Your Honor.
Okay, so it was put on for this afternoon. The last time I saw you, it was March 7th for all pending motions. Let me just read the record what I got, and then we'll take these in order, and then I'm happy to address anything else that either side would like me to. Since March 7th, we've got a defendant's motion to vacate stay issued February 16th, 2024, and or modify allowing the defendant's motion to dismiss charge of witness tampering to be resolved. That was filed on March 6th, 2025. The state filed a written response.
That's not me, that's a...
That with you all, but I'm going to schedule that for hearing today. I can't hear it today, but I can give you a hearing date today. That's all the new business. What was left over from the previous hearing on March 7th was the defendant's motion for order to show cause why the state should not be found in contempt for ongoing willful and flagrant. The first one I want to address is the defense motion to vacate the stay issued February 16, 2024, and or modify allowing the defendant's motion to dismiss the charge of witness tampering to be resolved, and that would be in case number 23-10594, CF10A. So whenever you're ready, you may proceed.
Okay, so they
and text messages
moved to dismiss, and the judge says, nah. Okay.
The matter, this count is up on appeal, dealing with evidence relevant to it, and the C4 motion directly addresses that. So until the 4th DCA is done with their proceedings in the matter, this court is prohibited from hearing.
Okay, so there is a motion now to lift the stay. As you recall, Melly had a whole freaking trial. Then there was a hung jury. So the original judge had seen all this evidence and he excluded it. He said, no, you can't present that at trial. The state then appealed. When the state appealed, that put a stay, aka a pause, on this new trial. Okay? So there is a motion to lift the stay so that they can move forward with this trial. Jiggy says, is that the same lawyer accused of misconduct? Yes, the lady with the long hair, Raven Liberty, is the one who is accused of witness tampering. And she is the one of which they subpoenaed and obtained her entire Apple iCloud record.
Substantive matters as it relates to that.
May I respond? This seems like delay tactics, Judge. You could take Mr. Demon's entire phone going back to when he was born. They're still not going to be able to prove witness tampering. 931, 4 different elements. Mr. Griffiths wants to make us believe that somehow you could look at emails from 2019 and
They're trying to get the witness tampering charge dismissed. So after the first trial, the state came and then charged Melly with witness tampering because they said he threatened his girlfriend. So now they're trying to get that charge dismissed.
their state of mind. Like, my client's not psychic. He didn't know this was going to happen in 2023. He didn't know his friends were going to get killed. So them saying it's material is disingenuous, Judge. So I would ask that we let the state, we proceed on the C4 motion, which is only to 1 count. There are still 3 other counts. We're not bringing this case to finality. I am just addressing the tampering, because on its face, They have not met their burden with the tampering, and they'll never meet their burden with the tampering.
All right, so, Mr. I'm looking at standard jury instruction 21.10, tampering of witness, which is 914.22, subsection 1. That's what you charge Mr. Dennis with in count 1. So what you're telling me is the state's position is that some of the evidence that is subject to the appeal is currently in front of the 4th DCA is evidence that you would use not only in litigating the motion to dismiss, but you use it in trial as well.
Correct.
Okay, so the state is saying, hey, that evidence that is causing the stay, we want to use that. I like how the judge thinks.
Okay. All right, so listen, I certainly understand the defense position, and I certainly would like to bring all these matters to fruition as quickly as we can. However, that being the case, I'm nevertheless constrained to follow the law. The plain text of 924.071 subsection 2 says, an appeal by the state from the pretrial order shall stay the case against each defendant upon whose application the order was made until the appeal is determined. If the trial court determines that the evidence, confession, or admission that is the subject of the order would materially assist the state in proving its case against another defendant, and the prosecuting attorney intends to use for that purpose, the court shall stay the case of that defendant until the appeal is determined. So I don't think they have any choice here but to rule in the state's favor on this. I don't have the jurisdiction. You all disagree about what the evidence does or doesn't show. I'm certainly not in any position, nor is this an evidentiary hearing where I'm going to decide who's right or who's wrong about that. Tampering, which would be
This is Melly's brother. He was at court today, and his mom.
Tend to withhold testimony or withhold something or affect testimony or truthful testimony, and then element number 3 says that the official proceeding involved in the investigation of and one choice is capital offense.
So, Judge, what they have to prove with 941, which is the most important element, is that Mariah Hamilton was served with legal summons to attend an official proceeding. In this case, under that statute, 941, it defines what official proceedings are. The only applicable one would be the trial that occurred in
Mariah Hamilton is his ex-girlfriend.
May of 2022. So with that in mind, that they must prove that there was...
You're making a jury argument. We're not at the motion to dismiss. The only way that I can grant your motion is if I decide under 924.071 subsection 2 that this evidence can be related at all. And the state's telling me that it is related. I understand your position is that it's not related, but...
I'm in the position that 924 does not apply because it is not materially related. And I've also I know you're ruling, but with that said, if that was so much the case, then why haven't they stayed Cortland Henry's case or Terrence Mathis's case? Because this evidence still can't come into their case. Fred could, or...
Very good point. So the evidence that has the appeal stay, it can't be used in any case at all until the appeals court makes its ruling, right? So because of that, Raven Liberty is now saying, well, they're moving forward with these other 2 cases without that evidence. So clearly it can't be that crucial.
Excuse me, Cortland Henry's attorney could come and adopt my C4 motion and argue it himself. At this point, they have not moved to stay that case and say that evidence is so important. So why could that work with the co-defendant, but not with Mr. Dillons? Because there's no logic to it, Judge.
I have no idea.
Very good question.
Nor do I have to decide which side's behaving logical or not. In my opinion. Lucky for me. So on this one, again, pursuant to 924.071 subsection 2, the defense motion to vacate the stay issued on February 16, 2024, and or modify, allowing the defense motion to dismiss the charge of witness hearing to be resolved. Respectfully, this may be denied. For the reasons I just stated on the record, I will enter the appropriate written order.
So although you have a rule, I would just leave this impression with the court. We did have this hearing. We did discuss the stay. The state had representatives that had no issue with this proceeding forward, and here we are back, a stay while he waits. Thank you.
Okay, the next one is the defendant's motion to compel discovery or an alternative to reveal the extent of the state's intrusion
Okay, this is the motion we went over last week.
on the defendant's right to due process, client confidentiality, attorney-client relationship. So, Mr. Henderson, I think you filed that whenever you're ready.
He did, Judge. And I talked to Mr. Aronson before the court took the bench today. When that motion originally came in, I emailed your judicial assistant and listed out some reasons why the state would not be ready to argue that today. I'm still in the process of creating a response as well as investigating some of the issues that were raised. I'm not prepared to argue that today. I would ask the court to
They're not prepared.
set this when the bond hearing is set.
Okay, that request is denied. Go ahead, sir.
This is the appropriate reaction. Judge said, nah. Oh, you need more time? Tough shit. We're doing it today. I like that. That's good. You know, this man has been in jail for like 2,200 plus a days. He's innocent. He's sitting there as an innocent man. That's why they're having a bond hearing, to see if he can bond out, because this shit's ridiculous.
the case law, you said you read it already, but I'll give you a whole packet because my secretary would be very upset if I make her make these copies and I don't give them to anybody.
Understood.
Your Honor, since you've read the motion and you've read the case law, it appears to me, appears to us, that you previously did not believe that you had the authority to conduct a hearing based upon whether there is a conflict between Ms. Liberty
And I did a video one Friday and I talked about that, where the judge refused to have this little hearing. Now they're coming back with the case law saying, no, you need to have the hearing.
Mr. Demmons, as far as are still representing him. I believe one of the cases that I submitted says that in fact the court can hold that type of hearing. But that's not the gravamen of this motion. The motion is really focused on the other Sixth Amendment rights: attorney-client privilege and effective assistance of counsel and due process under the Fifth Amendment. Now, all the cases I gave to the court, there's not one on point, because this area of the law seems to be incredibly fact-specific. But the one thing...
Because most prosecutors aren't going and subpoenaing the entire cloud file of the defense attorneys. It's unbelievable.
...that we know from all these cases is, A, the state should have revealed a year and some odd months ago, that in fact Ms. Liberty's Apple accounts had been searched. They did not do that. The case law seems to be very clear also, Your Honor, that because they have this material, and I jump ahead and I'll jump back, we don't know what they have. What we know is that they've seized Ms. Liberty's Apple accounts through a search warrant. But when asked whether there were other search warrants or whatnot, the state still has not revealed whether anything else of Ms. Liberty's accounts have been searched. They did tell us that in fact that no other attorneys' accounts were searched. But during a federal hearing as to Mr. Demmons being released, it was the interpretation of the attorneys there that the sheriff's office was saying there may have been other investigations of other people. We interpreted that to mean our investigator. We are not positive. It was muddled as far as what was being said. So there may be other investigations going on that we don't know of. But as to this, we know at least Ms. Liberty's Apple account was searched and seized, and everything in it was seized from the inception of the account on. Prior to her knowing Mr. Demmons, prior to the murders,
From the inception to the account on. From the day she opened her account, they have all her files. That's nuts.
Anything. They go back, I believe, to 2019 in January is when they're seeking, the information went back as far as that, but it also goes back into the historical stuff of the accounts, when it was set up, things like that. So even though it's maybe delineated for 2019, you get information that is part of the entire account. So they have all these records. We don't know what they are, but we have a problem because they have all these records. The case law, if you read it, says under the Sixth Amendment, if client confidentiality has been breached, we have to specifically file a motion delineating what we believe is client confidential. We cannot do that if we don't know what they have.
Right.
We have the right to go into whether or not the prosecutors on this case have been tainted by the material that they received in the investigation of Ms. Liberty. Remember, I only represent Mr. Demmons. I don't represent Ms. Liberty. So how this affects Ms. Liberty is irrelevant to me. But they have seized all of her accounts. In that, are there comments made about our trial strategy? Mm-hmm. Are there emails, are there communications, text messages about our trial strategy? How about whether or not she just met with Mr. Demmons and Mr. Demmons says this, and this? The bottom line of all of this is they did a mass seizure of everything in Ms. Liberty's Apple accounts. And in order to be able to defend him properly, we need to know what they have. We need to know whether it was received properly, whether it was reviewed properly by a taint team, whether they went beyond the taint team and things were discussed with the prosecutors. Now, if you went through all these cases, you notice trial strategy or what we're going to do, what we're planning, cannot effectively represent our client.
Okay.
So before I ask the state to respond, I see the 6 bullet points specifically that you requested. Return seized property that belongs to Mr. Demmons. I'm going to skip number 2 for a moment. Provide notice of defense to all the documents that have a bearing on attorney-client privilege. Provide the protocol that was used to segregate the information. Provide a list of witnesses who were involved in obtaining the search warrant, and any and all documents related to Ms. Liberty's accounts. I don't know if the cases that I read support all those specific requests, but my question is this: as to number 2, provide copies of all materials in the state's possession obtained from the accounts. Doesn't that solve your whole problem, at least for now, if I just order them to turn over everything they got?
It's a start, but it's not a finish. And the reason why it's not the finish, we still need to know whether this material was passed on to the trial team, whether they had a taint team. Those are things that we still need to know. So although, as I said, that's a start to order this all to be returned to us or copies of all of this, it doesn't get us to every place we need to go. How, by just them turning it over to me, how do I know that this incredibly confidential piece of information wasn't seen by the Tane team, called up Mr. Griffiths and said, God, you can't believe what we just discovered here. This will help you in the murder case. Here it is. We don't know that. I'm not accusing anybody, but the case law is pretty clear. We're entitled to find out if it was shared with these prosecutors.
If there is such material. And again, I'll repeat what I talked to you about before, but it's literally sitting right over there. You can have a discussion with Mr. Adelstein's motion next, but I entered an order February 18th, 2025. At least in part granting the request for discovery that you all would comply with 3.220. So you got these materials in December of 23. I don't see any discovery submission on the docket. So am I correct? The state has not made any supplemental discovery disclosure regarding any of these materials?
Correct.
Okay. So I presume that means you're not going to use any of this at the trial because
Correct.
you've had an obligation to do so and you
Yes.
haven't done it.
And that was my comment to the court.
If you're not going to use any of it at the trial, and again, to repeat myself, as I seem to do every time we all get together, since Mr. Demings is entitled to heightened due process because of the penalty that's involved here, you haven't charged Ms. Liberty with anything. You've had over 17 months to do it, 15, 16 months to do so. Despite your all's position, I've previously found that it's not an ongoing investigation because you haven't done anything. Now you're telling me there was no materials involved that were turned over to the state that even warrant you supplementing discovery. So if that's the case, what is the harm with me granting the number 2 request that you all just copy everything that was given to you and give it to the defense so they can see what it is?
Great question, Judge. Great question.
I can't find any harm at this point, so what's the harm?
So let me back up a little bit. So despite what the court feels is is no longer an open investigation, it does remain an open investigation. I have met with the detective. The investigation is still open.
All right, well, but that could be forever. I
Additionally-
hate to interrupt lawyers, but that could go on forever.
I can tell the court the case is actively being worked.
Well,
And
that doesn't mean-
and on top of that, well, because obviously I can't disclose to the court exactly what's going on.
So what's the plan, sir, if you don't mind letting me in on this? Now that I've special ordered 750 jurors in September, are you all planning on arresting Ms. Liberty 10 days before the trial, sir?
I can't disclose that at this point.
Well, okay, so my finding over your objection and the way I'm going to proceed forward is that there is no ongoing investigation. So that's the way I see it. Go ahead, do your next one.
All right.
Okay. Investigation closed.
Good. Well, following up with that, because I was working on a response. Criminal investigation is considered active as long as it's related to an ongoing investigation with a reasonable good faith anticipation of securing an arrest or prosecution in the foreseeable future. There is no statute or regulation on how long a investigation remains open. That's Florida Statute 119.011, Florida Freedom Newspapers versus Dipsey at 478 Southern 2nd, 1128, Avila versus Miami-Dade County at
Judge is irritated. Look at it.
29 Southern 3rd, 401. There's other citations, but that's the first 2. There's no time limit. And this, as an officer of the court, I'm telling this court this remains an open investigation. It is currently and still being worked. The materials that they seek, first of all, there's been no seizure. The case law actually talks about this. Copies of her Apple records were provided to BSO, which were then subject to the filter team, but she was never deprived of those records. She still has access to them. The lack of seizure, so there's been no seizure. The lack of seizure is echoed in rape.
Okay, so his argument is that because she can still access them, it's not seized. It's only seized if you can no longer access it. That's a good argument.
Search warrant to Google, which is at 232 Federal Supplement 708. In-ray search warrant issued to Google at 264 Federal Supplement 3rd 1268. U.S. versus Lorna, 333 Federal Supplement 3rd 172. Matter of search info associated with a redacted Gmail account at 2017 Westlaw 2480752. Which all cite to U.S. v. Jacobson at 446 U.S. 109. A seizure of property occurs when there is some meaningful interference with the individual's possessory interest in the property. There's been no
This is why you got to look at the judge's face while you present your evidence, like while you're making your argument.
seizure. We have copies, yes, but there's been no seizure. As the court has pointed out, she has copies, she has access. So she has what the state, she probably has more honestly, but she has what the state has. So she has access to whatever it is that we've reviewed.
And so then, if that's true, the harm in me ordering you to turn it all over, so then she'll have 2 copies, but what she already has is what?
I'm telling the court there's been no
Mic drop.
seizure and it remains an open investigation.
Let's say you're right, which you're clearly not, but let's say you are. He has to decide who wants his lawyers to be. We keep having the same discussion.
And
how many trials do you want to do?
And I'm protecting my open investigation, Your Honor.
How many trials do you want to do? If I was the defense, I mean, I wouldn't be laughing because I'm in court, but oh my God, I would be smiling ear to ear.
You all decided to do what you decided to do. Anything else you want to tell me about this?
Yes. So turning towards the points that were raised in M. Neal, which was in the defendant's motion, was evidence or is evidence going to be used at the trial directly or indirectly produced from the intrusion? No, we're not using anything. That's the subject of Mr. Adelstein's motion. We're not using anything. Was the intrusion by the government intentional? Yes, that's why we obtained a search warrant. Did the prosecution receive otherwise confidential information about the trial preparations or defense strategy as a result of the intrusion? No, we have not received anything. The trial team handling this case has received no confidential communications. And were overheard or any conversations or other information used in any way to substantial detriment to the defendant? No, because we're not using anything. We don't know anything about their strategy from anything that's been recovered. So they can't even establish the prongs that would require the court to compel us to turn over these materials.
He's right about that. We're not. This isn't an evidentiary, and you all are making an evidentiary hearing because you can call whatever witnesses you want, but no one's calling any witnesses. You guys are the lawyers. You're not witnesses. So I understand what you just said, but there's no record evidence of that.
I know.
You want to call some
I'm proffering to the court.
Crawford's not going to do it, sir. Today's April 1st. His trial's September the 10th. That's why you
Proffering cutting it, buddy.
might have noticed, although I don't prejudge anything, every time someone asks me to slow down on something, I deny it because it's time to do this work and get done with it. So I haven't heard anything yet that says don't turn it all over. So anything else?
And again, Judge, that is why I asked for additional time, because 4 days prior to this hearing, with the issues that I raised in my email to your judicial assistant, I still have not completed all my work in terms of
You're telling me
responding to
if
this.
I order you all to turn it all over to me, and I review every single part of it, you believe I'm going to determine that nothing qualifies under 3.220? Nothing they're entitled to prepare for trial?
Judge, we're not using anything.
That wasn't the question.
I understand the court's question. I'm telling the court, I don't have access to everything, because obviously there's a filter team in place.
You don't know.
Right, but I don't know because I'm not entitled to know, nor will I know.
But the state hasn't turned anything over.
Because we're not intending to use it. It's not going
That's
to
not
affect
what
Mr. Demons'
3.220
case.
says. It's not what you intend to use. That's their standard.
But that's
They
what
have to turn over
the
what they
case
intend
law
to
and the
use.
statute
You have to
law.
turn over everything that you know about.
If it intends to be used at trial or has
In contrast to Glanville, this judge is like, yo, turn it over. What?
any material
You have to turn over everything you know about if you're the state. Not just with trial.
merit, and based upon what we are aware of and what has been turned over, it is not.
Okay. Anything else on that issue?
One moment.
Okay.
All right, Judge. I'm sorry. The one other issue, which the other reason we asked for it is BSO was not noticed in this hearing. They are the investigators in this case. They are the ones in material possession of these documents. They're the ones that actually know more about the investigation than we do. I feel they have a right to be heard as well because in some of my initial research, when I was looking at things like public records requests, the lawsuits always involve the sheriff's office.
This isn't
versus
a public records
I
request
understand,
lawsuit, sir.
but I believe that our sheriff's office also has standing.
You're 3 for 3. I don't agree with anything you said. Anything else?
Again, I still haven't had an opportunity to fully address the motion, which is why I was asking for additional time.
Okay, over your objection. So the defendant's motion to compel discovery or an alternative motion to reveal the extent of the state's intrusion on the defendant's right to due process, client confidentiality, attorney-client relationship is going to be granted in part and denied in part, as follows. Which granted is the paragraph 2. Giving the state 20 days to provide the defense copies of all materials in the state's possession obtained from Attorney Raven Liberty's appellate counsel. The other 5 requests are denied without prejudice, depending on the outcome.
Thank you, Your
I
Honor.
will give you a written order on that.
Okay, so judge made a ruling, said you have 20 days to turn it over. The defense had asked for some sanctions, and they were they were supposed to hear that that day. The reason they wanted to ask for the sanctions is because the state had already been ordered to turn over the evidence more than 20 days ago and hadn't done it. So the defense withdrew that motion. They were winning with the judge. They did not want to piss him off. They said, let's just move along. And I think that was absolutely the best strategy. All right. I'm going to talk about Karen Reed, and then we're going to talk about Young Thug, I swear to God. Okay, so Karen Reed, they are still very much
Use of this
jury selection.
Questionnaire is helpful for several reasons.
All right, this is the judge telling them they're going to get a questionnaire. This was the third day and third round of jurors
First,
that came in.
there is some personal...
Kind of boring. Okay. You guys know that meme from Mean Girls? It says, why are you so obsessed with me? I feel like Young Thug needs to post that meme and at Fanni Willis. Okay, because what the... I don't care if Fanni had a sexual relationship with one of the victims from the RICO trial. I don't care. That is not enough reason for you to be this stupid. She is on his jock, and it makes no sense. So let's watch this news.
Hard for the law. 11 Alive's Karis Belger joining us from the Fulton County Courthouse. Karis, have we heard from Young Thug's attorney about this latest filing?
We have. Brian Steele did share a statement with our newsroom. In it, he says in part that his client did nothing wrong. As for this filing, it accuses Young Thug of intimidating people using social media. One instance in particular mentions a gang investigator who is also testifying in another hearing and was not supposed to be shown on camera per a court order.
A gang investigator who's been all over the APD's Facebook who's been all over social media is not supposed to be revealed. Oh, okay. Oh, by the way, I don't think not revealing her was any part of the plea deal. As I recall, the plea deal, it didn't have anything to do with Vivarudi, or however you say your name.
Alleges that after a known blogger shared a post with that investigator's face, Williams shared the post with the caption calling her the, quote, biggest liar in the district attorney's office. Later, the filing states that the investigator's address and those of her relatives were shared online, and it also says...
And, okay, exactly, tell me exactly how Young Thug violates his probation by people responding to his post. Explain to me how the plea deal that I heard read out loud in open court, we talked about on this show, how it was violated by people responding to his post, especially in the US of A, where we have the right to free speech.
As threats were made against Fulton County DA Fanni Willis. Young Thug's attorney Brian Steele shared the following statement with us. It says, this motion is baseless, and while intimidation and threats of violence are never appropriate, Jeffrey Williams has done nothing wrong. We look forward to seeking a dismissal of this petition. So a note about Young Thug's probation agreement, he is not allowed...
Okay, and by the end of the day yesterday,
to engage in any
so
sort of...
Fanni filed that Wednesday. By the end of the day yesterday, YSL Whitaker had already tossed it out. Thug had posted at Twitter a post of Detective Vitorito, or whatever her stupid name is, and said biggest liar in APD. And they tried to get his plea revoked. Whitaker didn't even have to have a hearing to sign that dismissal order. But I really wish she had, because I would have liked to see the prosecution argue such a ridiculous motion. I would have enjoyed watching that stupid argument, breaking the argument apart, thinking how terrible the argument is, and then watching the judge do the same thing. That would have been really fun for me. So I'm a little disappointed that we didn't get a hearing on that, but I am happy to see that Judge Whitaker is still making good rulings. Fanni needs to get a life. If I was in Atlanta, I'd be so pissed about all my money that she spent. Like, you spent all my money on this? And now you're spending my money on this again, right? Like, because now you're still going after this? Like, no. All right, guys, that is the show for today. I thank you so much for joining me. Don't forget to write down on your calendars May 6th. We're going to have our meet and greet in New York City. And hopefully next week, but maybe the week after, we will have an exclusive interview with John Hunter, who is Tay-K's defense attorney. So I'm really looking forward to that. Thank you so much for all your likes, your subscribes, your shares. I'm at almost 14,000 subscribers. I'm probably at 14,000 now. And it's unbelievable. I couldn't have done it without you. Like, thank you so much. A special shout out to my members. Thank you guys. You guys are the greatest. I promise I'll get you some content soon. I swear. Thank you, everyone, and I'll see you next week.